decision from 2013, Rule 704, does not prevent an expert from drawing conclusions about intent, so long as the expert does not profess to know a defendant's intent. So that's what the essentially the prosecutor's handbook tells us about this rule. Let's look at an opinion. United States versus Alvarez, 837 F. 3rd 1024. This is a 1988 decision. It's the same language. Operative language of 704B says that an expert may not state an opinion or inference as to whether the defendant did or did not have the mental state or condition constituting an element of the crime charged or defense thereto. This means that the expert cannot expressly state a conclusion that the defendant did or did not have the requisite intent. Curiously, the case cited in the state's motion on paragraph 6, State versus Cowan, I'm assuming the court's been provided a copy of that. Well, first of all, that's a non-published opinion. And what it's cited for is absolute dicta. That there's nothing at all in that opinion whatsoever that has anything to do about an expert testifying to the defendant's mental state. Nothing. Nothing at all. So, knowing that that's the law, we will be very sure to tell not just Dr. Diamond, but anybody, any expert that's called to testify for us, that they cannot give testimony to the ultimate issue as prohibited by the law. They can't get up there and say he's not guilty. They can't give an opinion that he did not act with malice. They can't give an opinion that there was no criminal negligence. They cannot give an opinion that it was not intentional. They can't give an opinion that it was not an accident. Now, we'll acknowledge that certainly the summary that was provided to the state suggested that Dr. Diamond would be in a position to give an opinion that this was not intentional. And that is in fact his opinion, but we will make it clear to Dr. Diamond and any witness that is not appropriate for them to use that specific language, that anything that happened was or was not intentional. So to that extent, Judge, frankly, I think that we agree on what the law is. But I believe that the witness absolutely can testify to his opinion that based on his experience that what happened here was the result of a failure of memory systems. That's not the ultimate issue. I mean, a jury can decide if they want whether it was an accident, whether it was intentional, whether it was malice, whether it was criminal negligence. That's the ultimate issue. So to that extent, Judge, I think that I don't think there's going to be any objections during the trial because we're not going to attempt to offer ultimate opinion testimony as prohibited by law.
I guess that was a 10-minute way of saying that they agree with us. So we'll accept it, and we ask that you order that they not allow the defendant or defense expert to then give an expert opinion on the criminal intent of the defendant.
Well, Rule 704B applies to expert opinion about any mental state, and it's not restricted to testimony concerning insanity. I mean, that's U.S. versus Awful, OFFILL 66 F3 16A. So I grant the motion. All right. Mr. Evans is back. Do you want to proceed or flip back to what was we were doing.
Judge, I think I have two more motions to handle that are about as lengthy as the prior one, so
Let's go ahead and get those done.
thank you, Your Honor.
That makes sense to me.
And the next motion I have, Judge, is the motion limiting to exclude the testimony of Dr. Agakar in this case. Your Honor, I think looking at the motion and again, and looking at his what he's provided, what the defense has provided in their opinion summary of the expert, and then also looking back at what he told me, I think that whereas it looked like I was going to attempt to try to exclude everything that he had put in here or told me about him testifying to, I think that if he does offer up opinion based on not necessarily what he told me, but what the defense put in their expert opinion, that he would testify about how people react differently to stress and trauma and things of that nature, I think that would be admissible if they do go that route. So I'm going to limit my motion to exclude testimony of Dr. Agakar in the ways, and I'll talk about that in a minute, how I'm going to ask you and what I'm going to ask that you exclude. First of all, procedurally, as I told you, we talked to him the day his name was provided, April 6, 2016. Dr. Agakar, actually, I spoke with him on that day. He talked to me for a while, provided me a one-page summary of his work and his statement with the defendant that's just handwritten back from February 9th, 2016. When I talked with Dr. Agakar, he had told me he'd reviewed these different reports and things like that. What troubled me is that he was going to be offering as an expert to basically talk about the credibility of witnesses and get his opinion about people's perceptions at the scene, specifically the defendant. And he would try to give an opinion that, based on what he has viewed, that the defendant's statement could have been genuine, and that he thought, his actions were genuine at the scene and at the station. Now I asked him further about that, and he said, well, yeah, it's possible he was not genuine, he was acting, or these behaviors were out of the ordinary, but he wanted to give the opinion that he thought the defendant was being credible, basically. So what we're asking is that the defendant or the defense expert be banned or excluded from doing that, but also he, through the statements he gave to me and that were provided in this recitation of his interview with the defendant, he wanted to give statements that, based upon the defendant's statements to him, basically trying to elicit lay testimony or testimony that you do not need an expert through the prism of an expert. For instance, Judge, in speaking with him, in addition to him saying he wanted to give that expert opinion on the credibility of the defendant as far as his behavior at the scene, he also talked about, in my discussions with him and with his statement to the defendant, that he wanted to talk about, he said he expected to testify about that the fact that the defendant does not like to show emotion in front of a bunch of people. And he wanted to do that and testify as an expert about that to try to buttress the defense's argument. Just some other things. He was going to try to explain why the defendant used cop talk, how he knows criminal statutes, how he's comfortable about police, explaining other issues in the case, basically based upon what the defendant told him, and at this point you've ruled, or at this point, inadmissible. What he is trying to do, this Dr. Agakar, I don't know if the defense has talked to him about this, and they know that he had told me he was going to try to testify to these things. He's basically trying to use expert testimony to explain the defendant's statements and basically try to get his defense out without the defendant taking the stand in the case, and that is completely and wholly improper. There are several reasons that Dr. Agakar's opinion testimony about what he's reviewed about the crime scene, what he's reviewed of witnesses' statements, I guess to try to talk about the credibility of their statements and things like that, several reasons why those should be excluded. First, this testimony is inadmissible because you cannot testify about the credibility of another witness, and you especially cannot come in and have an expert testify about the credibility of other witnesses. United States v. Warner, which is 2013, United States District Lexus 186862, It's Northern District of Georgia, April 7th, 2014. In that case, the defendant attempted to have an expert opine that the defendant was telling the truth based upon polygraph examination. In that opinion, the court held that the jury is the lie detector based on the evidence that comes out, and determinations of credibility fall within the exclusive province of the jury. Another person's opinion as to credibility based on a brief encounter at another time and place, in this case, almost 2 years later, for an hour and 45 minutes, talking to the defendant and reviewing bits and pieces or perceptions of the crime scene, what that does, it supplies the jury only with another opinion in addition to its own about whether the witness was telling the truth. Further, Warner cites Humbert versus the City of College Park, which is 2007 United States District Lexus 98174, that's Northern District of Georgia. In that case, it cites United States versus Ballou, that's Billue, that's a 1993 11th Circuit case. I do not have the cite on that. But in citing that case in the Humbert case, which is in Warner and is provided, the credibility of the defendant is a matter within the exclusive province of the jury, and also not helpful to the jury because whether someone or not is telling the truth is not beyond the average understanding of a layperson. Also, Judge, this is inadmissible, him talking about the defendant and try to give expert opinion specifically about the defendant's behaviors at the scene and whether they were credible or not. I'd cite to U.S. versus Monroe, which is 2015, United States District Court, Lexus 153479, 2015 case. They held there that testimony of an expert was tantamount to expert opinion about whether the defendant had a mental state necessary for the crimes charged. In that case, the defendant did not dispute that he had provided protection during a time when there was some type of drug dealing. He just claimed that he didn't knowingly do it. That's very similar in this case. The expert's going to try to basically provide expert testimony to explain his behavior at the scene, and I believe stating like he did to me that he was going to give these opinions, that he was genuine, that would invade the province of the jury. And Judge, further, there would be further argument if the defense attorneys do try to get into statements the defendant made to the expert about why another reason this would be inadmissible would be the gist of everything he told me he was going to testify about was an attempt to be an end around to get the defendant's statement in, and would merely be a conduit for inadmissible hearsay. In trying to get the defendant's statement out, basically, most of what Dr. Agakar told me that he wanted to testify about were things, and based on things the defendant told him 2 years later. All of those things, which I summarized earlier, are things for which, if they're based in the evidence and they come out, do not need expert testimony to explain. Oh, he used certain language because he used to be in law enforcement. You don't need an expert to testify about that. The defense can make and argue about that. That is not something that is outside the average experience of a layperson. So, Judge, I do ask that you exclude any testimony by Dr. Agakar regarding whether he believes the defendant's reactions as opposed to other people, whether his opinion is that they were genuine. Also, I would ask that you exclude any attempts for him to try to go into statements made by the defendant and then explain in some expert mode something that would be ordinarily understood by a layperson. We do not challenge, or at this point we do not challenge Dr. Agakar if he's going to come in and he's qualified in the field of how people react to stress and trauma.
We know from the first time that this case had any hearing, first time anything was done in court, at the probable cause hearing back in July of 2014. We knew from that moment that the state, part of their case was to proffer evidence and insinuation and argument that Mr. Harris's actions or inactions or his behavior or his responses suggest a lack of remorse or suggest some knowledge or nefarious intent. This is a big part of the state's case. We've received a lot of discovery, and we've gone through a lot of materials in 2 years. It's very clear this is a part of the state's case that they're going to try to drive a truck through. We have the right to confront that. We have the right to put up evidence to contest that. And so we have enlisted Dr. Agarkar. He has reviewed certain materials in the case. He has spoken with Mr. Harris. He's provided to the state his written notes. And what the state wants to do is they want to file a motion to cut out any mechanism for us to confront their case, for us to confront any evidence that they're saying suggests that his behavior responses were not remorseful or otherwise nefarious. In doing so, I think this motion is a bit misleading. Looking at it, paragraph 5 says the nature of this testimony is proffered by the defendant in the 2-sentence summary. This is their motion. Seeks to admit expert testimony on the credibility of witnesses and defendant. Well, take a look at the summary we provided them, and all we've indicated was he was going to offer an expert testimony opinion in the area of stress and trauma relating to the defendant's actions and reactions in connection with the death of his child and his arrest. So I think the state is wrong, very wrong, when they suggest that his testimony that would proffer would have anything to do about the credibility of witnesses and the defendant. They cite to the court one case in support of this, which is United States versus Warner. This is, I believe, another unpublished district court case, which essentially says, well, where you've got a lie detector evidence, somebody can't come in and say, yeah, they were telling the truth. Yeah, they were lying. I think that's pretty obvious. That doesn't have anything to do with what we're talking about here. Paragraph 6 of their motion says that in the 2-sentence summary I just read to the court, that the defense is seeking to serve as a mere conduit for otherwise inadmissible hearsay. Well, that's not at all what the summary says. That's not at all what we intend to do. That's not at all the purpose of calling Dr. Agarkar as an expert. But this is the way the state wants to sort of couch it to preclude him from being able to come in and testify. Paragraph 7 says, again, they're looking at the summary that we provided, and they say that our summary seeks to admit extrinsic evidence of specific instances of the defendant's conduct regarding truthfulness. Well, that's not true. That's not true at all. That's not what is in the proffer, and it is not, in fact, what it is that the purpose of Dr. Agarkar's testimony. So, take a look at a couple of cases that I want the court to be aware of. The rule that we're dealing with is 24-7-703, and so I went back to the prosecutor's handbook, Carlson on evidence, and looked at some of the cases that they cited in there. And one of them is Velasquez. And the summary of Velasquez, and I'm on page 457 of the 4th edition. Nope, there's no problem with expert opinion based on an expert's interview of the accused plus her review of his medical records and conversations with other experts. Well, when we go and read the opinion, what it's clearly saying is that experts are permitted to testify to statements of the accused which form the basis of the expert's opinion. It's just this simple. You know, anytime you've got an expert who's going to give an opinion, who's taken information from all kind of different sources, and it's certainly not uncommon for one of those sources to be some statement or statements from the accused. That's part of the basis of their opinion. And that's what there's nothing remarkable about that at all. And that's what the state here suggests. Well, we can't hear any of that because it all goes it all deals with credibility. And so we can't hear any of that. That's not the case. Want the court to take note of another opinion, Reinhard, R-E-I-N-H-A-R-D versus the state. This is a 2015 case, the Court of Appeals 331, Georgia Appeals 235. In this case, we're looking at the defense is suggesting that the trial court should have excluded the testimony of a therapist and psychologist because it did what? Well, it bolstered the testimony of the child. The court disagreed, and what they said is this: the fact that such testimony may indirectly, though necessarily, involve the child's credibility does not render it inadmissible. Looking at Odom versus the state, in that opinion, there is absolutely nothing wrong with expert opinion testimony that bolsters the credibility of the indicted allegations of sexual abuse. The victim's psychological evaluations was consistent with sexual abuse. The therapist came in and the psychologist came in and gave specific testimony that the symptoms and the behavior were consistent with a child experiencing serious trauma from sexual abuse. Psychologist testified that each girl's demeanor and behavior during her forensic interview was consistent with that of a child who had been molested. So, what we're talking about here is really something that happens every time that we have a child case. Certainly, is that you've got experts that might look at a statement of the child at the time, as well as a forensic interview, and then offer an opinion on it, whether or not that behavior is consistent with what it is the expert is opining. And that's all we're talking about here. We're not talking about discussing the credibility of any witnesses. We're not talking about being a conduit for a statement of the defendant so he doesn't have to testify. That's not at all what we have proffered. I wasn't privy to the conversation that Mr. Boring had with Dr. Agarkar, but I can tell you from our perspective, that's certainly not why we would be offering this opinion. We would be offering it for exactly the reason and purpose stated in our proffer. He will provide expert testimony and opinion in the area of stress and trauma relating to defendant's actions and reactions in connection with the death of his child and his arrest. So I think the state's motion is misleading, and it's trying to reframe and recouch what it is that Dr. Agarkar is going to be testifying about. So in that regard, Judge, I would ask that you deny this motion.
And Judge, I did base it mostly on asking Dr. Agarkar to explain what was meant by that summary. What do you mean by explaining trauma and things like that? And I agree, if the defense, and that's something we can approach down the road, much like in a sexual abuse case, if they ask questions about, is this behavior consistent with something like this, somebody that suffered trauma? I don't see any problem with that. What I'm objecting to is Dr. Agarkar explaining the summary by saying, I'm going to opine that I thought he was genuine in his reaction. Obviously, in a child sexual abuse case, the defense would throw a fit if we had witnesses up there saying, yeah, I thought the child was genuine and truthful. Of course, that would be improper. That's exactly what Dr. Agarkar told me that he was going to testify about. Further, what he keyed in on when he told me, what I'm seeking to exclude, if there are other things that they want to get into down the road that don't fit what he told me, that maybe that'll be admissible. But based on what he told me, he also said he was going to try to get into things of explaining the defendant's conduct for which there would be no reason to call an expert. The defense, we're not trying to prohibit them from explaining certain things if they want to. There's evidence admissible both from the defendant's statement, from their witness, and things like that to explain why he might be quirky, or why he might talk a lot, or why he might do this or that. You don't need an expert to come in and transmit that. That is something that they can get out through other evidence that you do not need an expert to use as a conduit for hearsay and inadmissible evidence. When the defense talked about 24-7-703, Judge, what you cannot do under that is facts and data that are otherwise inadmissible shall not be disclosed to the jury by the proponent of the opinion, or inference unless the court determines their probative value in assisting the jury to evaluate the expert's opinion substantially outweighs the prejudicial effect. And the starting point is it's inadmissible unless the defense can come in here and show, well, this is going to exceed the prejudicial value substantially, the probative value is. Judge, we don't have that here. We're not even at that point. All we have is this is inadmissible evidence under the rule. While an expert can rely on stuff that may not be admissible at trial when they form their opinion, studies, things like that, what they can't do is put it before the jury. That's exactly what Rule 703 says, and that's exactly what Mike's Train House versus Lionel says. 472 F. 3rd 398, which is a Sixth Circuit case, 2006. The expert in that case relied on statements and hearsay and opinions of others, other experts as well, and attempted to disclose all of this evidence to the jury. The Sixth Circuit Court of Appeals in that case affirmed the language in 703. Here it's worse. They're actually attempting to admit substantive evidence that is otherwise inadmissible, that's 2 years later, after the defendant's hearing statements, things like that. He's trying to go through an expert, according to Dr. Agarkar, when he's telling me what he's going to testify to get out his story and explain it through an expert. So, Judge, we are not trying to keep the defense from presenting their defense. We're trying to keep them from doing it in an improper and inadmissible manner. So, in sum, I'd ask you to exclude the defense expert from being able to give an opinion as to whether the defendant was genuine or truthful or not, and then also prohibit them, the expert, from going into statements of fact that would be giving an opinion on things that a layperson could, about why he might talk a certain way if he was a police officer. These are things that can be explained through argument and through other witnesses, not given them the imprimatur of an expert.
Well, I'd like a motion regarding credibility. As to the second part of it, that's a bit broad. I'm going to deny it, but there's not to be argument about it, and when the witnesses are there, we can take a proffer and make a, I think, more accurate ruling. What do we have next?
Judge, before we pick back up with Mr. Evans' motion, we just have one other motion. Be a motion in limine for a jury view of the car. We've already withdrawn the motion to have a scene view. Your Honor, in this case, just wanted to file this motion just to alert Your Honor and defense what we'd be attempting to do. I guess logistically it's a little bit more difficult now that we're not going to be right next door to the police department, but we are trying to make accommodations to, in fact, have the motor vehicle in question, the defendant's car, towed to Brunswick. If we do that, we would like the opportunity to actually have an evidentiary view. We believe that with this, the way the courts look at jury views, it can either be an evidentiary view where you're looking at evidence which is just too big, bulky, or affixed to actually fit in a courtroom, and you also have scene views, and the standards are different about what can and cannot be done. We can see that this is an evidentiary view. We would be looking at evidence, having the jury view evidence in the case. The case that really describes the difference in these two views is Jordan versus the state, which is 247 Georgia 328. It describes the difference between an evidentiary view and a scene view. So, Judge, we would be asking to actually conduct a jury view of the motor vehicle. Looking, just kind of going forward, maybe to think in the future, if Your Honor grants the ability to do this, we'll sit down with the defense and maybe discuss it with Your Honor in court later, what the rules and procedures we're going to do or follow to do it, depending on the circumstances in Brunswick and where we can go, where we can set things up. I know just looking at Esposito versus the state, which is 273 Georgia 183, that's a 2000 case. They do talk about certain things that should happen. The trial judge should attend the view, court reporter should attend, the defendant and the defense attorney should attend, and specifically the witnesses involved should not attend. So just as I'm asking permission for Your Honor to allow a jury view in this case, and then as we get down there looking at what we're dealing with as far as space and logistics, how we might set it up. I just provided those cases to see some of the limitations that we may have to do once we get down there.
Case cited by Mr. Boring, Esposito versus the state, 273 Georgia 183. That's a 2000 case, Georgia Supreme Court. This is the warning that our Supreme Court gave. Because jury views have proved to be a fertile ground for irregularity and at times reversible errors, the parties to criminal trials and trial courts should carefully weigh the real benefits of a jury view before planning one. Frequently, as in Esposito's case, the jury has already viewed photographs of the crime scene. And nothing is to be added to the jury's understanding of the issues to be tried by an in-person visit to the scene. Now, the vehicle here is the same. In such cases, a trial court would be authorized to deny a request for a jury view. In this particular case, the jury's going to have photographs of the vehicle, not only at the Acres Mill location, but likely in other locations as well, as including the evidence shed. That's the highest and best evidence of that vehicle. Not only that, we expect there's going to be video of walk around with inside and outside of the vehicle. So I guess the question is, what's the purpose? And the jury's already going to have not only photographs, likely video, they're also going to have extremely, extremely detailed measurements of inside and outside the video. So is the state going to put the car seat back in the vehicle? So we know it's been taken out and put back in, taken out and put back in. Are they going to put the car seat back in? Are jurors going to be invited to get in the back seat? Or perhaps sit in the driver's seat? They're going to be allowed to lean in and try to toss light bulbs across the front seat? What we're talking about is creating evidence. When they've already got the evidence they need in photographs, in video, and measurement. So why does the state want to do this? Well, they want to put jurors inside a crime scene and invite them to substitute their view for what Mr. Harris's view might have been, or was. For instance, as jurors approach the vehicle, if they approach from the driver's side, from the front, they're going to be looking into the windshield to see if they can see a car seat, to see what they can see. Well, I submit to the court, if you're looking for something, you're gonna see it. And that's what the state wants to do here. And the question isn't whether a juror, putting them in that place, whether they can see it. The question is whether Mr. Harris could, or did. And the jury's gonna have all the evidence they need in multiple photographs, video, and measurements. Well, they can be invited to sit in the driver's seat themselves and look over their shoulder and look in the rearview mirror to see whether or not perhaps they personally would have seen something, would have seen a car seat. That's not the issue. Okay, the issue is whether Mr. Harris could or did. And so you're really, it's like a golden rule issue, really, Judge. By doing this, what we're talking about is inviting the jury to decide something based on their own bias, their own opinion from the evidence they're creating by being there in the scene, rather than Mr. Harris, rather than the evidence that day, the photographs, the measurements. I think it's plain and simple. It's asking each and every juror to substitute their vision for Mr. Harris's. I also think this is incredibly, incredibly, incredibly dangerous for us to go down there to try this case and try to do something like this. As fraught with problems as it could be. What if it's a hot day? What if it's a particularly hot day? Are we going to invite jurors to get in that vehicle and sit, see how hot it is? Maybe substitute their opinion or what they feel for what the victim felt. That's really what we're talking about here, what the state wants to do. Just like a golden rule violation. And so the last question I would ask is, if they don't intend to do all this, if they don't intend to have them walk up to the car, if they don't intend to open it up, have them sit in the driver's seat, have them sit in the back seat, then why are we doing it? Because we got a big old stack of photographs of that car from every angle you could imagine, inside and out, that are coming in. We've got crime scene detectives that took a mountain of measurements. All that's coming in. Nothing, absolutely nothing is gained. The jury learns nothing more by going to sit in that car or going up to that car. It only invites the jury to substitute their view for Mr. Harris's. I strongly encourage the court not to go down this road.
Judge, this, as I said, is not a scene view. This is not a scene. What we're asking you to allow us to do, as we should be allowed to under the law, is allow the jury to look at the murder weapon. That's exactly what this is. The state alleges that car was the murder weapon. While there may be pictures and things like that, I appreciate the defense wanting to try my case for me and tell me what I can and can't do and what I need and don't need. However, I have a sneaking suspicion, well, maybe they will cross-examine the crime scene techs about their photographs. And maybe they had bias about how they took them. And maybe they had bias about the angles that they took these photographs. And we didn't get all the angles. That's why we're seeking to introduce the actual murder weapon in this case. Judge, the case law is clear that we are allowed to do this. He wants to throw out this parade of horribles of all these things we're going to seek to do. All I asked was to bring the car down and let the jury look at it. And then Your Honor can get limiting instructions, can tailor this view as we can all see fit to keep those dangers from taking place in this case, but to allow the jury to see the actual item of evidence that was used in this case.
I think in theory it's time to bring the vehicle and have a view. I think the details of how it will be conducted. Right now it's subject to speculation. That's what we've been doing. I don't find that a valid approach to making decisions. We'll have to have a hearing and flesh out what will and will not be done, where the vehicle will be, what day, what time of day, and under what circumstances, and what the jury will be observing. You'll need to be prepared to make a very explicit offer of what you expect to have and do, and when and where. And you need to let them know in advance so they can think about it and be ready to express their concerns, thoughts, objections, opinions.
Yes, Your
What do we have next?
Honor. Your Honor, I think we're at a point where we can pick back up with Mr. Evans' motion he was handling.
All right.
Let's go. Detective Stoddard will return to the stand. Judge, these would be motions 21 and 22 that we're back on.
So we're back to number motions.
Those are the defense motions.
Well, like I said, that's not.
You're welcome.
Makes things a little.
All right, Detective, when I left off with you, we had just authenticated some photographs that I believe were entered and admitted. You recall that?
I do.
And I'll remind you, by the way, that you're under oath still from earlier this morning before we took our break.
That's correct. Yes, sir.
These photographs that I now have in my hand, states 1 through 5, to refresh the court's recollection, these are photographs of the defendant by his vehicle at the Home Depot parking lot shortly after the lunch break from that particular date. Is that correct?
That is correct.
And what I'm going to ask you to do is just to hold these up one at a time for the court so that Judge Staley can see those, and just describe, using your fingers, point out where that vehicle is and where defendant can be seen. States 1.
And states 1, if you look here in the corner, that's going to be the defendant's vehicle, defendant in the door frame with the door open.
And you just set that down on the bench beside you to the left. Let's go through 2. Each one of these are obviously a still shot in time from this event that you observed from the Home Depot video, correct?
That is correct.
And the record should reflect these have all been admitted without objection. True?
Yes.
Go ahead.
And the second photograph, Judge, it's the same. The vehicle is in the left-hand corner. That's the defendant's vehicle and defendant in the door frame.
Similar fashion, states exhibit number 3, if you could hold that up and describe to the court what that depicts.
Number 3, it shows the vehicle again in the same position with the defendant outside of the vehicle.
And then the last 2 items of evidence, 4 and 5, just hold those up, and it shows essentially vehicle in the same spot within the parking lot and defendant within that door frame, correct?
That is correct.
And you can just put 4 and 5 up to the left. We'll start with this particular area. You're familiar with who David Dustin is, correct?
I do. I am. I'm sorry.
And David Dustin does some 3D crime scene scanning and mapping. Is that accurate?
That is very accurate.
In this particular case, we enlisted the services of Mr. Dustin to scan several areas, the first of which was that Home Depot parking lot, correct?
Several areas were, yes.
Let's talk about the Home Depot parking lot first, because we'll kind of do it chronologically from that day. Did you actually participate in any way in the scanning process or make that parking lot available to him so that he could use his Faro 3D scanner?
We just made the parking lot available. We worked with Home Depot security. We put up cones, make sure the parking spot was empty that the defendant had used that day. And I did accompany him to 2600 Cumberland to watch him perform the scans.
In similar fashion, at some point in time, was he also provided access to defendant's vehicle so that he could perform scans both inside and outside of that vehicle?
Yes, sir.
And you were a participant in making that vehicle available to him so that he could conduct his 3D mapping and 3D scanning, correct?
That is correct.
Now, once these scans were taken, I want to focus on the Home Depot parking lot and the vehicle. Did you discuss with him and provide information to him about the location of the vehicle and defendant as he stood in the door frame such that he could adjust his 3D scan to account for that?
I did.
And specifically, the photographs that we provided to the court, do they demonstrate where specifically you told him the vehicle would have been located from the Home Depot video as defendant stood in that door jam?
They do.
And have you had an opportunity to review Mr. Dustin's scan of the actual Home Depot parking lot that includes the vehicle and where the defendant was standing?
I have.
Does it accurately demonstrate spatial proximity and location of where defendant was as he accessed the vehicle on that date?
It does.
Does it accurately demonstrate where the vehicle was parked within the parking lot from that date?
It does.
The second scene I now want to talk to you about, you talked about the final resting place by Little Matteo's, correct?
Yeah, Uncle Matteo's.
And we have several photographs and some videos of defendant's vehicle there when we wrote that off as a crime scene. Is that correct?
That is correct.
And did you at some point ask David Dustin to also scan that area for purposes of presenting that in this case?
I did.
And did you accompany him, you and Cobb County Police Department, to sort of cordon off the area so that he would have the ability to do that and get an unobstructed 3D laser scan or image scan of that particular area?
That is correct.
In similar fashion with the Home Depot parking lot, did you also give information to him about where defendant's vehicle would have been parked during the day of the crime in that particular location?
I did.
And have you seen the scan of that area that was created by David Dustin using his 3D imaging software?
I have.
Does it accurately demonstrate where defendant's vehicle was parked when you responded to that crime scene?
Yes, it does.
Does it accurately demonstrate spatial proximity of the vehicle to the buildings that are also scanned and located within that 3D scan?
Yes, it does.
We had touched on this just a little bit, but the scanning process also allows you to get some smaller scans too, is that correct?
That is correct.
Did you allow Mr. Dustin to access the interior of the vehicle so that a scan could be conducted with the car seat and the mannequin placed in the vehicle?
We did.
And having responded to the crime scene and seen the vehicle, was the car seat accurately placed in the vehicle where you saw it on the day of the crime?
Yes,
And have you seen that scan as well?
I have.
Does that scan accurately reflect spatial proximity of items within the vehicle?
It does.
And does it accurately demonstrate the interior of the vehicle and how it looked with the addition of the mannequin that was added to demonstrate where Cooper Harris would have been?
That is correct.
And were these 3D scans made in substantially similar conditions to the event in question?
Yes.
Were they made so near the same in a substantial particulars as to afford a fair comparison of what you saw, for instance, on the Home Depot video with the 3D scan?
I believe so.
And similarly, were they made so nearly in the same in substantial particulars as to afford a fair comparison of the 3D scan to what you saw at the final resting place of defendant's vehicle,
I believe so.
as well as the interior of the vehicle, correct?
That is correct.
The actual scans themselves were placed on a hard drive. This will be stage 6. State 6 is going to be a small manila envelope containing two things. One is a hard drive, and then one is a flash or thumb drive. You recognize this hard drive as being the hard drive that Mr. Dustin put the 3D scans on.
I do.
This this thumb drive creates an actual scan of the interior of this courtroom, correct?
Correct.
And included on the hard drive is the 3D imaging scan of this courtroom as well to demonstrate the accuracy of the 3D scanner.
I believe so.
And you were asked to initial these after viewing it to confirm that it accurately demonstrates these things that you've just discussed, correct?
Correct.
These are your initials right here on
That
the
is
hard-
my initial.
And then CFG, that's Carrie Grimstead, your crime scene technician that
Yes, sir.
worked in this case too?
That is correct.
And you had him, looks like
The day before.
day before he signed that. All right, for one of the scans in particular, I need to ask you this question, well, for two of the scans. Did you obtain information the defendant provided to the Cobb County Sheriff's Office when he was booked into the jail in terms of his height?
I did.
Okay. And do you recall what his height was, self-disclosed height, his admission during to the jail staff?
Yes, it was 6'2".
And at some point, did you have a discussion with David Dustin about the defendant's height to account for certain things that were included in the scanning process?
I did.
And specifically, did you share with David Dustin that he was 6'2" by his own admission to Sheriff's Office staff?
That's correct.
Detective, I think that's all that I have for you at this juncture.
I'd like to play the video, and I'll question him afterwards, Judge.
Your presentation, you have a problem with that?
Well, I was going to authenticate that with my next witness, is Mr. Dustin, who's going to come in.
No?
Authenticate the video?
Yeah, I've just had him confirm certain things. I haven't tendered it, it hasn't been admitted yet. I was going to get Mr. Dustin to come in to talk about the 3D scanning process before I did tender state 6.
Okay, well, let's hear from Mr. Dustin then. I'll question him after we've seen the video, Judge, if that's okay.
All right.
Before you leave the stand then, let me just ask you one question about the mannequin for, I think it states exhibit number 22. When
Yes.
you saw Cooper Harris were his eyes open,
Yes.
and his mannequin accurately reflect that?
Yes.
That's all I have for you.
All right. You can step down.
Call David Dustin.
And I'll go ahead and ask for the rule at this point.
I think they've been observing that anyway, but noted for the record.
I'd like Detective Stoddard outside of the courtroom when this witness testifies.
We'd ask for an exception to the rule for the lead detective. He is the case agent on the case. We think it would assist us with the orderly presentation of our case. So we would ask that for motions hearing as well as the trial itself.
This dad's probably tried 100 murder cases. We're talking about one witness. I don't think he's going to use Detective Stoddard to lay a foundation for this witness.
I'm gonna allow the exception.
You solemnly swear affirm the testimony you shall give to the court on this mountain will be the truth, the whole truth, and nothing but the truth.
I do.
Be seated.
All right, sir, if you'll introduce yourself to the judge, spell your first and last name for our court reporter, the gentleman seated before you with the glasses.
My name is David James Dustin. First name is D-A-V-I-D. Last name is Dustin, D-U-S-T-I-N.
Where are you employed, sir?
I'm self-employed.
And what do you do?
My company is Dustin Forensics.
And what does Dustin Forensics specialize in?
We specialize in 3D laser scanning, also 3D animation, training of various agencies and entities that desire to use 3D laser scanning.
Tell the court, please, what is 3D laser scanning?
Yes, sir. 3D laser scanning is effectively using a laser to capture an environment or a scene. Effectively, at least the application that we use of it It has it's a 1550 nanometer laser beam that effectively is projected onto a scene or to an environment. Think of it as painting the area with light, if you will.
So,
And-
I'm sorry, I didn't think of it as,
painting the room or the environment with light.
thank you.
So it's projected from a central point from the device. Once the laser data is captured, then there's a second operation with a color camera that captures the coloring, if you will, of the environment as well.
So it's based both on a laser as well as photographic evidence?
Yes, sir, that's correct.
And what specifically is the name of the product that you use to accomplish this 3D laser scanning?
And we use a Faro X330 laser.
Can you spell Faro for our court reporter?
F-A-R-O.
What sort of training, education, and experience do you have that qualifies you to use this Faro 3D laser scanning imaging capture device?
I was originally trained by the manufacturer effectively before it was used in any kind of forensic capacity. From then on, then we applied the scanning technology and assisted the manufacturer in developing it for use with law enforcement and also engineering. Helped them to develop the case and the course curriculum, testing manner, things like that.
And have you ever been tendered as an expert in 3D scene mapping and 3D laser scanning before?
I have, here in Georgia and then also in June in the state of Tennessee.
And in fact, you were tendered by me as an expert in a murder trial that was conducted before Honorable Judge Adele Grubbs recently. Is that correct?
Yes, sir, that's correct.
Judge, at this time, I would tender David Dustin as an expert in 3D laser scanning and crime scene mapping.
What's his name?
I'll question him. I'll question after Mr. Evans finishes.
I'll let him testify.
All right. In this particular case, you were called upon by our office in Cobb County Police Department to assist in some crime scene mapping. Is that correct?
Yes, sir, that's correct.
I want to talk to you about 3 specific locations that appear to be the subject of these motions. The first one is the Home Depot parking lot. Are you familiar with that area?
Yes, sir, I am.
And can you tell the court, were you provided an opportunity by Detective Stoddard in Cobb County Police Department to conduct 3D laser scan and image capture of the parking lot in question?
Yes, sir, I was.
And describe to the court what the process was and how it is that you were able to accomplish that task.
Yes, sir. So effectively, you place the scanner, the 3D laser scanner, in positions around the scene, and then the software, or excuse me, the scanner will capture the data from the scene. The number of scans on the scene depend upon the level of capture desired as far as the amount of detail. Then the software, you take the data and you insert it into a computer, and it does what's called registration, which is effectively placing the scans in the proper orientation.
If we wanted to describe the scanner itself, essentially what it looks like is a tripod. Is that correct?
Yes, sir. The scanner itself is, think of an old style lunchbox. It's approximately that size, and it has, it mounts on top of a tripod.
And the scanner essentially spins and takes slices of laser scanned and then makes image capture. Is that correct?
Yes, sir. So, there's an onboard. The laser is emitted from an inside cavity that's reflected by a mirror. The mirror is rotating, and as the mirror rotates, then it projects that laser beam onto the surfaces. And then once the laser capture portion is completed, then the camera will rotate and will take a series of 85 images, stitch those together to create a panoramic image, and then also that colored data is applied to the laser scan.
In this particular case, you were asked to scan several large areas, including the Home Depot parking lot.
Yes, sir, that's correct.
Did that take a period of time, and did you make multiple laser scans in order to have all of that data available to your computer system?
Yes, sir. It took approximately 2 hours to scan the Home Depot parking lot.
At some point in time during this case, did you also have an opportunity to scan defendant's vehicle?
Yes, sir, I did.
And are you able, using this software, to use that scanned vehicle and insert that into the parking lot in the exact area where the vehicle would have been parked per the information given to you from Detective Stoddard,
Yes, sir, that's correct.
as well as the defendant and where his location would have been from captured Home Depot video?
Yes, sir, that's correct.
The judge has already seen State's Exhibits 1 through 5. One of them is actually right here beside you on the left. I showed you these images.
All of them,
All of them are.
I believe.
You are correct. They're all here, Judge. These images to show you the capture of the actual defendant's vehicle and defendant from Home Depot video.
Yes,
Do you
sir.
see that?
Yes, sir.
And having conducted your Home Depot laser scan and having talked to Detective Stoddard about the precise location of defendant and defendant's vehicle during the day of the crime in question, did you ensure that your scan of the parking lot included and demonstrate where defendant's vehicle was on that day?
Yes, sir, that's correct.
I'm gonna object to that. I don't believe this witness has testified that he saw those photographs, at the time. Based on his report, I don't think he's ever seen those photographs before.
I'll ask the question this way. Did you see those this morning?
Yes, sir, I did.
And you have the 3D laser scan you created, correct?
Yes, sir, I did.
Does your laser scan accurately demonstrate, as those photos depict, where defendant's vehicle is and where he was standing?
Yes, sir, they do.
And did you obtain that information prior to looking at the photographs from this man here, Detective Phil Stoddard?
Yes, sir, that's correct.
Using the 3D laser scan, are you able to maneuver the scans that we can actually see things from different angles?
We don't actually maneuver the scans, but we can maneuver the camera inside of the virtual environment.
Did you also speak to Detective Phil Stoddard about the final resting place of defendant's vehicle, the crime scene that they responded to where Cooper Harris was located?
Yes, sir. In addition, when we had performed the laser scan at that location, the paint markings were still on the asphalt, so that we could use that to also place the vehicle.
I want to ask you a little bit about that. Have you ever used this scanning process to assist step units or traffic enforcement units for vehicle-related crimes?
Yes. With the step unit specifically, it was a case where an individual was lying in a roadway and they were impacted by a vehicle.
That's the case where you testified as an expert in a trial that I handled, correct?
Yes, sir, that's correct.
As with this particular case, in that case, were there also markings on the roadway that you were able to utilize and incorporate into your scan data?
Yes, sir, there was.
So let's talk about Little Matteo's then, the final resting place of the vehicle. Did you use this same 3D laser scanning and image capture process at that location?
Yes, sir, I did.
And using the markings that were there on the ground from this particular case, were you able to place the scanned vehicle that you had of defendants in the exact location where police officers found it from the response to the crime?
It was approximately in the same location, yes, sir.
And does it accurately demonstrate spatial proximity and distances within that scene that you scanned?
Yes, sir.
About how long did it take you to scan that area, do you recall?
It's approximately an hour and a half to 2 hours.
You'd already given some testimony about this, but I want to talk about the third scan in question in this particular motion, the scan of the interior of defendant's vehicle.
Yes, sir.
Was there a scan that was performed on the inside of the vehicle as well?
Yes, sir, there was.
For our record, when you scanned that, there was also a car seat that had been placed in the vehicle with a mannequin of Cooper Harris?
Yes, sir, that's correct.
And describe for the court how it is that you were able to accomplish that scan within the interior of the vehicle.
So the tripod that the device sits on or is mounted on top of it's adjustable. And so effectively what we did was we adjusted the height of the laser scanner, placing it in the driver's seat. And the defendant and I are approximately the same height. I asked Detective Stoddard to view me sitting in the seat, and then once I had placed the 3D laser scanner in that same location. I asked him to verify the accuracy of the placement.
Okay, so did Detective Stoddard tell you that the defendant is 6'2"?
I remember him saying approximately 6'3", but that's what I remember.
Okay, and about how tall are you, just for our record?
About 6'3".
Okay, and the scanner, did you adjust it to essentially eye level inside the vehicle?
Yes, sir. Eye level with me.
And were you able to get a 3D scan of the interior view of the vehicle with the car seat and with the mannequin of Cooper Harris in that car seat?
Yes, sir. That's correct.
Does it accurately demonstrate the interior of the vehicle as you observed it?
Yes, sir.
Does it accurately demonstrate spatial proximity of items within the vehicle, including distance, for example, from the scanner to the car seat that was in the back seat?
Yes, sir. It does.
For all of these animations, I shouldn't say animations, for all these mapping, these scans, are you able to go in using the software and actually make measurements as well?
Yes, sir. That's correct.
And how is it that these items of evidence can actually be presented in court?
From a graphical standpoint, you're
Sure.
asking? Yes. So you can, either using the software, you could do a screen capture of a measurement. You can also, you can display the panoramic images in a variety of methods. One is you can export the panoramic image and view it on an iPad. The other is you can also view that image within the software.
For the last scan that I was talking to you about in terms of our discussion, to confirm the height of the scan, can you actually look in the rear view mirror to see if you can see out of the back of the vehicle using the laser scans you captured?
Yes, sir, from the images, yes, sir, you can.
All right. To demonstrate the accuracy of this software that you use, at some point I asked you to come and actually scan this courtroom so we could show Judge Staley how it works. Is that correct?
Yes, sir, you did.
And we did that in similar fashion in the other trial we had before Judge Grubbs.
That's correct.
And this is State Exhibit number 6. The external hard drive that you have here, it's got your signature and a date on it, correct?
Yes, sir, that's correct.
And you recognize this as being the hard drive that contains the laser scans that you've just given testimony about.
Yes, sir.
In addition to that, I asked you to bring in, as part of State 6, a scan of this courtroom from the judge's bench perspective.
Yes, sir.
At some point, did you have a 3D laser scanner that was essentially where Judge Staley is seated now?
Fairly close. I believe it was on the top rail there, or possibly on the desk area.
So when you're talking about the iPad technology that you have, did you send that to me, and did we place it on the external hard drive so we could demonstrate for the court how the scanner would work from that vantage point?
Yes, sir, that's correct.
And that's the blue thumb drive included in State 6?
Yes, sir.
Attender State 6.
Admitted.
All right. What you did here in the courtroom, is that the same scanning process that you just discussed for all of the crime scenes that we've talked about?
Yes, sir.
Okay. With that, I'm going to ask you to step down, and we're going to use this microphone here. I had this queued up earlier today. I'd like you to show the court exactly how this works. We'll make sure we use the microphone so that our court reporter can hear us. If you'll bring up the 3D scan of the interior of this courtroom so we can demonstrate for the court how the software works.
So what we've done is we've captured the environment inside of this courtroom with a 3D laser scanner. And it'll take just a moment for the data to populate. But then, so the scan data is incorporated together. It's something called registration, which means that the scans are oriented to each other. And then, because we have these laser scans, now we can actually move through this environment, this 3D environment, virtually.
And this is the interior of Judge Staley's courtroom as you scanned it some months back when we gave you access. Is that correct?
Yes, sir, that's correct.
And the scanning process that you've just talked about, where you take multiple scans from multiple locations, that was accomplished in this case so that you could demonstrate the accuracy of it, correct?
Yes, sir, that's correct.
And if you will, show the court how you're able to move through this 3D captured image to show the various areas within the courtroom.
So we can move to different positions. We can move above the jury box. We can move around to the court reporter's viewpoint. We can move to either defense or prosecution desks.
And does this technology allow you to demonstrate distances and spatial proximity of items within the area that you scan?
It does. So we can acquire an image. So for instance, I can measure from the base of this podium to the corner of the table, and it will give us that distance. Change your units.
Of course, that would have been at the podium at the time that it was scanned, correct?
Yes, sir, that's correct. So it's approximately 6 3/4 feet.
And you can do that in similar fashion with any area that you've scanned using your 3D Faro technology, correct?
Yes, sir, that's correct.
Did you use this same process on the 3 areas that are subject of the motion, that being the Home Depot parking lot, Little Matteo's, and the interior of the vehicle?
Yes, sir, and as well as the exterior of the vehicle.
I want to talk a little bit about the thumb drive. Do you have your iPad in here?
I have it up there.
If you will, the thumb drive, that's a component of State's Exhibit number 6. You have that scan actually incorporated onto an iPad, is that correct?
Yes, sir, that's correct.
Could you bring that up so we could show the court? Why don't you step up here with me and we'll just let the court take a look at it. So included on State's Exhibit number 6, can you see around my shoulder? Is this a scan site from behind the judge's bench, correct?
Yes, sir, that's correct.
All right. And that's actually included on the thumb drive that's a part of State's Exhibit number 6, correct?
Yes, sir.
And from that, using the 3D technology, you're actually able to make a scan, essentially, if the judge were standing up, of what she might see in the courtroom.
Yes, sir, that's correct.
Did you use this same process for the interior of the defendant's vehicle as you've described?
Yes, sir, I did.
Back to you.
Has the defense seen that?
I gave it to him this morning. I did show Mr. Rodriguez, yes, on my phone.
Do you want to look at it again? You got me a note? All right, we're good.
The purpose of this 3D image capture is to demonstrate spatial proximity and distance. Is that correct?
Yes, sir, that's correct.
Okay. Well, in particular for the item that they're complaining of, the scan of the interior of defendant's vehicle, you did not make that scan to demonstrate what defendant may or may not have actually seen. Is that accurate?
I did not make any assumptions as to what he could see or could not see.
Rather, just the interior of the vehicle as it happened to appear from that particular height and that particular scan point.
Yes, sir, that's correct.
In similar fashion to what we just showed Judge Staley from the scan of this courtroom from the location where she's generally sitting now.
Yes, sir, that's correct.
All right.
Good morning, Mr. Dustin.
Good morning, Mr. Kilgore.
Just a couple of things. I'm gonna move this, give me a little space. Just a couple things I want to make clear. Mr. Evans asked you twice about appearing before Judge Grubbs.
Yes, sir.
In this courthouse, right?
I believe it was this courthouse, yes, sir.
Okay. And isn't it true that in that particular case, this evidence was not in any way challenged by the defense, was it?
That's correct.
You didn't appear at a motions hearing and have to go through any procedure like this, because everybody just agreed, yeah, we want all that to come in.
That was correct.
Okay. And have you used this technology in a trial in Cobb County other than that case?
No, sir, I have not.
Okay. But you have in Metro Atlanta?
I was, the other one was the one I mentioned in the state of Tennessee.
Okay. So that's the only time you've actually testified in a trial using this technology?
Yes, sir, that's correct.
And it's fair to say it's a new business, it's new technology, and you're trying to get it off the ground, right?
It's actually been around for a while. It's mainly been adapted or adopted into forensic use probably within the last 5 to 6 years.
Okay. You haven't even charged, you're not even charging the DA's office anything to do all this work, right?
I am not.
And the reason is because, again, it's new, and you're trying to get exposure for this technology so that you can, at some point in time, be paid to do this very kind of work, right?
Oh, it's kind of a loaded question. My motivation for doing this is to get exposure to the technology. Yes, that's true.
Okay. So we've seen this little sort of demonstration this morning with the courtroom example. And I want to ask you a little bit about that. The scanning that you did of the courtroom was an absolutely 100% static, fixed, exact space. And there were no other variables that you had to account for, were there?
That's correct.
Okay. In other words, you walk into an empty courtroom and you just scan it. You don't have to account for something that was there earlier and is not there now.
Correct.
But what you did in this case wasn't exactly the same thing, was it?
Well, when we scanned the Home Depot parking lot on July 4th, I don't recall there being any vehicles in the parking lot besides ours. There really were, if there were variables, it would be us.
All right.
Us in the same proximity.
All right. Well, let's just go with that first then. Was there did you bring a vehicle, and was a vehicle placed in the parking lot?
There was a vehicle in the vehicle I drove, and I believe the vehicle Detective Stoddard drove. Yes, sir.
All right. And was that vehicle purportedly the defendant's vehicle, Mr. Harris's vehicle?
No, sir. No,
Okay.
sir.
What was it?
There was my vehicle and Detective Stoddard's vehicle.
All right. So it was not defendant's vehicle that was scanned in the parking lot at Home Depot?
No, sir, it was not.
Okay. And Mr. Evans asked you if the vehicle that you scanned in the parking lot was in the exact location.
He did.
Your testimony wasn't that it was in the exact location, but it was approximate.
I said it was approximate, yes, sir.
Okay. And the reason for that is that there's some guesswork involved. That's a variable, because you are trying to recreate exactly where a vehicle may have been when you come into a scene where the vehicle's not there. It's been removed, right?
I wouldn't call it guesswork, the reason I say approximate is because I wasn't there and I did not scan the scene that particular day. So I don't know exactly where it is. I can approximate it, but I don't know exactly where it is.
Okay. You can approximate it.
Yes, sir.
And what's the margin of error? How many inches or how many feet one way or another, to the left, to the right, front, back?
I would say a safe estimate is probably within 3 or 4 inches of where it was.
All right, so the variable is within 3 or 4 inches,
That would be my estimate, yes, sir.
okay? And where are you getting that estimate from?
And that's based on looking at the photographs and then also interacting with Detective Stoddard.
All right, well, let's start with the photographs. Because according to your report, you got exactly one photograph of the vehicle, not Mr. Harris's vehicle, but a vehicle in the parking lot? Or did you get a video that was clipped out from the surveillance video?
I did not see any video surveillance of the parking lot.
All right, let me just show you this. I'm gonna show him his report. Okay. Is this the video, is this the photograph you got?
Yes, sir.
Okay.
It was in color.
All right. So if this purports to be a photograph cut from a surveillance video, that's all you got?
That and working with Detective Stoddard. So I placed it initially, and then I reviewed it with Detective Stoddard if that would accurately depict his opinion of where the vehicle was located.
All right, we'll get there. What I want to make clear is, you got exactly one photograph that was cut from a surveillance video. You did not receive those photographs that you apparently were shown this morning.
That's correct.
All right. Is there anything else you were shown this morning that you hadn't seen before?
No, sir, not that I recall.
Okay. All right. So can you tell us the date in which you received this photograph?
No, sir, I don't recall.
All right. Was it before or after July the 3rd of 2014?
It would have been after.
After July the 3rd.
Yes, sir.
All right. If I were to tell you that your report indicates that you did the 3D laser scanner at Home Depot on July the 1st, 2014, does that mean that you did the scan before you ever received the photograph?
Actually, I believe we scanned the Home Depot, it was the 1st or the 2nd of July. And yes, the answer is correct. I did not have the photograph before I scanned it.
All right. Do you need to see your report?
Sure.
How many times did you scan the scene at the Home Depot?
I scanned it twice.
Twice?
Yes, sir.
And one of those being July 1, the other one being July 4?
It was July 1st or July 2nd. It was very close. The first time it was very, the parking lot was full. And so we opted at that point to just terminate it and come back when the parking lot would be empty.
What'd you do with those preliminary scans?
I included them in the raw scan data.
All right. When you went out there and did your scan on July the 4th, did anybody make you aware that there were surveillance videos that captured Mr. Harris's vehicle that morning of the 18th?
I don't believe we talked about any of that. I could see that there were surveillance cameras in the parking lot, but I don't know that we discussed it prior to that.
All right. Did you ever request to see the surveillance videos?
Not that I recall.
Okay. Just at some point in time, you became aware that perhaps they existed?
That's fair. Yes, sir.
Okay. And in putting these together, I mean, it's fair to say for accuracy, you want as much actual information as you can have, right?
That's sure.
Okay. And you would agree with me that an actual surveillance video of the events in question is pretty much the highest and best source of the events in question, right?
No, not necessarily. I would say scene photographs are going to be much better. A scene diagram is going to be much better.
Okay. photographs or a diagram are gonna be better than a video of the actual event occurring,
I'm talking about, if we're talking about location of a vehicle, that's what I'm talking about.
okay? In addition to the single photograph you had, you indicated that you had to get other information from Detective Stoddard as to the location of where the vehicle was in the parking lot, right?
I believe that's correct.
Okay. When did he give you that information?
Oh, I don't recall specifically. We scanned the area, and he just instructed me where the correct location was, where the correct stall was.
Okay. So did he tell you that on July the 4th, the day that you were out there doing the scan?
Yes, sir, and actually the first day we were out there.
Okay.
If I remember correctly, that particular parking spot was blocked off with cones, and I think that it was taped off as well, if I remember correctly.
All right, and then y'all moved the tape so he could put another car in there that was not Mr. Harris's car.
No, we didn't do any of that.
All right, so you scanned the vehicle in the parking lot, in a parking spot, other than the one depicted in the.
Are you talking about the first day, Mr. Kilgore?
Talking about the day you did the scan.
Which scan, sir?
The scan that has been turned over to us of the vehicle in the Home Depot parking lot.
That would have been scanned the July 4th. There were no other vehicles other than my own and Detective Stoddard's in the area.
Okay, and on that day, July the 4th, Detective Stoddard told you where the vehicle should be parked in the parking space, right?
He just indicated which parking space the vehicle was in.
All right, and did you put the car in the parking space, or did he,
You're talking about virtually or in reality?
in reality?
In reality, we never put the vehicle back in the space.
Okay, you did the entire scan with no vehicle being there at all?
That's correct.
Okay, and what you're telling us is the margin of error is 3 or 4 inches to the left, to the right, to the front, to the back?
Yes, sir?
And that margin of error is based on the accuracy of what Detective Stoddard told you, right?
I would say that's correct.
Okay, so let's just say he was off 2 feet,
Yes, sir?
okay? That would affect the accuracy of your scan.
Of course.
And again, we don't have any variable like that in the example that Mr. Evans showed the court of a static courtroom, correct?
I'm sorry? Say that again?
We don't have any variable such as guessing exactly where the car was or getting as close to as possible. We don't have that kind of variable in the example that Mr. Evans went over with you and the judge during your direct.
That's correct.
All right, so part of the scan, or part of the creation that you did involved placing an individual, a cartoon figure, if you will, at the vehicle, correct?
Yes, sir, that's correct.
Right. And let's talk about where you got that information from,
Yes, sir?
okay? Were you shown any videos or photographs depicting on where any individual was standing at that car?
Just the one, and then the 4 that I saw this morning. But at the time I created that, I had the one photograph.
Okay, just the one photograph that's in your report?
Yes, sir?
All right. So how did you get the information to know where to place the cartoon figure in relationship to the vehicle, where his head was, where his eyes were fixed, where his arms were? Where did you get that information?
From Detective Stoddard.
Okay. And you would agree that the accuracy of the scan, or rather the creation that you made, the cartoon, I mean, it's going to be based entirely on the accuracy of what Detective Stoddard told you.
That's correct.
So if he's off an inch or two, then your creation is going to be off an inch or two, right?
That's correct.
And if he's off 3 feet,
If he's-
your creation's going to be off 3
If
feet.
he's off 100 feet, it's
Okay.
off 100 feet.
And if perhaps the video, the creation that you did shows 2 arms in the vehicle, when in fact there was only one arm in the vehicle, that would be an inaccuracy in your creation, right?
I suppose that would be true, yes.
Might as well put a sticker on this. I'm gonna show you what's been marked as Defense Exhibit 1. I've showed this to the state's lawyers. You recognize this image?
Yes, sir, I do.
What is that?
That's a still frame of, it appears to be from a video, still frame of a character placed with arms reaching into a vehicle.
All right, and you would agree that that's a still from your creation?
Yes, sir, that's correct.
All right, I'm gonna move Defense 1. No objection.
Admitted.
All right, so just so the court will have something fixed to look at there. In Defense 1, we see a cartoon figure standing in the door frame of a vehicle with two arms extended into the vehicle, right?
Yes, sir, that's correct.
Right. Where did you get that information that somebody had two arms inside a vehicle like that?
From Detective Stoddard.
Okay. Where did you get the information as to where the cartoon was looking?
From Detective Stoddard.
Okay. And what about the depth of the cartoon figure in proximity to the vehicle? Where did you get that information?
From Detective Stoddard.
Okay. So if he's right, you're gold, but if he's off, your creation's gonna be off, right?
That's correct.
That particular figure shows that there is no, apparently no windshield, no roof, no windows, no back windshield. You would agree that that is what is depicted on the image, right?
That's correct.
Okay. Did Detective Stoddard tell you that the car in the Home Depot parking lot did not have a windshield, did not have a roof, did not have any windows, did not have a back?
No, sir.
Okay. So is that something then that you just decided to do on your own?
So, as far as the back of the vehicle being hidden, or what you're calling it, looks like a convertible, there's actually something you do in the software where you can place a rectangular object and it will effectively hide the data inside of it. So that's what we did, and I remember talking about that, and early on, Detective Stoddard was part of that conversation. How do we, can we somehow make a portion of the vehicle invisible or hidden so that you could see what was inside?
All right. So you were never given information that the car in the Home Depot parking lot was a convertible?
No, sir.
You were never given information that the car in the Home Depot parking lot did not have a windshield, windows, or a back window at all?
No, sir.
Okay. Detective Stoddard asked you to remove all of those items for purposes of your creation?
No, sir. So if you're asking about the windows, the reason the windows are not in there is glass is one of those types of objects that do not scan well. It's prone to reflection, to refraction, and so those items are either hidden or removed from that scan.
All right. What about roofs of vehicles? Did those scan well?
Yes, sir.
Did Detective Stoddard tell you to take the roof off the vehicle?
We talked about doing, yes, sir, he did.
He did?
Yes, sir.
Okay. Did he tell you why?
Just so that we could view the spatial relationship, so we could demonstrate the location of everything within the vehicle. Now, earlier frames of that show that the roof is in place. So it was just faded to show that, to reveal what was inside.
All right. You would agree then, even without ever seeing the actual vehicle, you would agree that photograph, which was taken from your creation, is absolutely inaccurate as to what that vehicle looks like.
State the question again.
That is not an accurate representation of what the vehicle looks like, is it?
It looks like the vehicle with the clipping box applied is what I would say.
Okay. And is the vehicle in question, has anybody told you that the roof was taken off of it?
No, sir.
So I'll ask you again, that photograph that came from your scan, that is not an accurate representation of the vehicle in question,
It
is it?
is an accurate representation of the vehicle with a clipping box in place, sir.
Okay? And you didn't come up with that on your own, you were directed to do that by the police department.
Yes, sir, that's correct.
We can see in that image that there is a car seat and a child's head. You see that?
Yes, sir, I do.
Okay. Tell me where you got the information regarding the placement of that car seat and the child's head.
I did not place the car seat or the child. The mannequin.
Who did?
Detective Stoddard.
And were you at any time ever made aware that that car seat had been removed and put back in?
Yes, sir, I was.
Okay. Did you ask them about whether or not the car seat was in the exact same location?
I didn't question their placement of it, no, sir.
Okay. And you didn't put the mannequin in the car seat?
No, sir, I did
All
not.
right. So again, for purposes of accuracy, you've got to rely on the information that's being given to you by Detective Stoddard.
Yes, sir, that's correct.
Would you agree that photographs of the actual vehicle would be the highest and best evidence of what that vehicle looks like?
It would be one, yes, sir.
Okay. Well, what if we had several dozen images of the vehicle from the exterior all the way around and several dozen images of the vehicle from the interior? You could get a pretty good idea of what the exterior and interior of that vehicle look like from those images, right?
It would be two-dimensional, wouldn't be, there would be no depth to it, it would not be in 3D.
Right. And we couldn't take the roof off, right?
With the photographs?
Mm-hmm.
That's correct.
Okay. And we couldn't, your word was maneuver or manipulate.
I didn't say manipulate,
No, that's my word.
okay?
You can't maneuver in a photograph, right? But in your creation, you can maneuver all around.
That's correct.
Isn't that kind of what you can do with a video? If you have a video of the exterior of a car, you can walk all the way around it. You can video the interior, and you literally can move that video camera anywhere within the vehicle, right?
That's correct.
Were you made aware that there were such videos in this particular case of the exterior and interior of the vehicle?
No, sir, I don't believe so.
All right, would that have been something that perhaps you would have wanted to at least have a look at for purposes of accuracy?
No, sir.
Okay. You received some information regarding the cartoon figure standing next to the car there in Defense 1. And essentially, all of that information came from Detective Stoddard, right?
Yes, sir, that's correct.
Okay. And I believe your testimony is Stoddard told you that he was how tall?
Approximately 6'3", I believe.
Approximately.
Yes, sir.
Okay. And you are how tall?
Approximately 6'3".
Okay. Because I believe that what I wrote down that you said on direct was that Stoddard said he was 6'2".
I don't remember saying that.
Okay. But you're 6'3".
I said approximately, if I said anything, it would have been approximately 6'2" or 6'3".
Right. And I mean, what we're talking about here really is a matter of inches. proximity to the car, where the head is, where the arms are, the height of the individual. We're talking about a matter of inches, right?
Anything is a matter of inches, sir.
Okay. But those inches have direct bearing on the accuracy of your creation.
Sure.
Okay? And you have to rely on the approximation of the information you were given from Detective Stoddard.
That's correct.
If he's right, you're gold. If he's off a little bit, well, not so much, right?
That would be a correct statement.
So in creating this, in creating these digital images, did you actually get in a vehicle, or did a human person actually get inside of a vehicle to do the scan?
Which scan, sir?
Any scan from the interior of the vehicle?
Yes, sir, I did.
All right. Tell us exactly how that works.
Well, there are two different scanning technologies that we used. One was what's called the terrestrial scanner, or the Faro X330. The other is a handheld device, which is you control it, you view it from a tablet, you control it by hand, and you use that to capture the what I would call more of organic shapes or curved shapes. It works better for that. And that's what we use to capture the scan of the interior of the vehicle.
All right. Well, what I want to know is this. Did somebody sit in the driver's seat of that car while the scan was working? Or did somebody sit in the driver's seat of that car and use a handheld device to create the scan of the interior?
Two questions. So the first one, did someone sit in the driver's seat? I sat in the driver's seat to capture the interior of the vehicle. Yes, sir. I opened the doors. I scanned the interior of it with the handheld device. Did I answer your question?
Okay. And does the placement of the handheld device, does it have any bearing on the accuracy of what you're scanning?
Yes, sir. It does.
How so?
Are you talking about the actual placement of the device in general?
Yes, sir.
It's relative. In other words, it does something called tracking, where there are objects inside of the vehicle that it uses to track or maintain that, so that the sequence of images that it captures.
Okay. So if you hold the device at one level, you're going to get a different image than if you hold the device maybe 2 inches lower.
Actually, ideally, you regularly change up the angle and location so that you capture everything related to this technology is line of sight. If you can't see it, then you can't capture it. So regularly you will position the device in a variety of different locations and orientations to capture the data.
Okay. And again, a video from all different angles inside a car, pretty much going to do that very thing, right?
No, sir.
It's not?
It's not going to capture anything in 3D space. It'll just be two-dimensional.
All right. And were you told by Detective Stoddard that what's going on here is that y'all are trying to recreate what Mr. Harris saw or could have seen?
No, sir. Never.
Okay. Well, what did he tell you we were doing then?
We were just we were capturing the scene, capturing the data. Never did we discuss what Mr. Harris would have seen.
Okay.
That's not my job.
Well, in fact, this is the first case that you've ever had where that's what was going on. You were trying to recreate sight lines of an individual.
No, sir. It's not. Well, criminal, yes. Civil cases, quite a few actually. Driver's perspectives, things of that nature.
Okay. This is the first criminal case you've ever had where
That's-
You're essentially trying to recreate sight lines from a person.
That's correct.
But you say you've done it in a civil case?
Yes, sir.
Okay, how many times?
I'll be conservative, I'll say 5.
Okay. And in those cases, did you also just sort of rely on what a detective told you to get as close as you could?
It wasn't a detective, typically it was an accident reconstructionist. They're always the end all. They are the expert. My job is to demonstrate their opinion.
The creation that you made from the vehicle's location at Acres Mill Square, when did you scan that area?
I believe we scanned that on the 4th of July, 2014.
July 4th?
Yes, sir.
Okay. And did you bring, or did anyone bring an actual vehicle to place it somewhere in that parking lot?
No, sir. No, other than the vehicles we traveled in.
Okay. So what you did was you just scanned the parking lot area,
Yes, sir.
right? And then you later came back and digitally put a vehicle in the parking lot,
Yes, sir, that's true.
okay? And how did you know exactly where to put the vehicle in the parking lot at Acres Mill Square?
I placed it within the paint marks that were still on the asphalt,
Okay,
and then again verified with Detective Stoddard.
okay. Was he with you at the time? Were y'all working together? Was he assisting you in creating this?
Assisting in creating what?
In creating the digital creation that you made?
I made it, I positioned the vehicles, and then we met, and I showed him what it looked like.
Okay. Were you given any photographs?
I don't recall.
Okay. Were you ever made aware that there were numerous measurements that were taken of the exterior and interior of the vehicle?
I don't believe I was.
All right. Did you ever ask for those?
No, sir.
Okay. Were you asked to create a panoramic image for the interior of that vehicle?
Yes, sir. Well, you can create a panoramic image from any scan data. I believe I made Detective Stoddard and Mr. Evans aware that we could do that.
All right. Do you know what a fisheye view is?
I do.
What is a fisheye view?
Fisheye view is where you use what's called a fisheye lens, which is effectively an asymmetrical lens that produces distorted, also known as a fisheye image. Yes, sir.
All right. In any of the digital creation that you made, was any sort of fisheye technology or anything akin to fisheye used?
No, sir.
Okay. Tell us about the panoramic image. You would agree that is not how the human eye observes the landscape or anything in front of it, right?
I think that's true. It's just a panoramic image.
Okay. And what was the purpose in creating panoramic images? Why were you told to do that? Do you know?
Just so that there would be a viewpoint or a way to visualize, what you could see from that particular vantage point.
All right. Well, in your report on page 12, do you have your report with you?
I do.
How much longer should cross-examine?
I don't think it will be long, Judge. I think a couple of minutes, I'm probably going to cover everything.
Thank you.
Yes, sir.
All right. So it says that a panoramic image was exported from the software showing an approximate view from the driver's, I assume you mean driver's seat. And then you say, Mr. Harris's approximate eye level position was verified by Detective Stoddard.
Yes, sir, that's correct.
Okay, so in creating this panoramic view, you had to rely very heavily on the information that Detective Stoddard gave you as to where Mr. Harris's eye level was.
Yes, sir, that's correct.
Okay. And the image that is on page 12, you agree that this was an image that is cut or comes from your digital creation?
It's an export from the software.
Okay, well, it's part of the video, right?
Video, sorry?
It's part of the digital creation that you made that's on the disk.
Yes, sir, that's correct.
All right. And is it fair to say that from this panoramic view, you're actually looking at the interior, the back seat, excuse me, the back of the driver's seat? And by that I mean, if this is the driver's seat, the panoramic view that you're showing us actually is taken from this position here where you're looking directly on the back, the seating part of the driver's seat.
Well, the device captures in effectively 360 degrees, so everything within that visibility area is going to be seen.
Okay.
Including something directly behind the camera, in front of the camera, on top of the camera.
Sure. You would agree that that image, the only way that landscape could actually be seen is if someone was essentially in the place of the steering wheel where they were looking at the seat of the driver's seat, the sitting part of the driver's seat. Is that fair to say?
I guess that's true, yes, sir.
Well, if you can explain it in a better way, please do. I'm giving you that opportunity.
Sure, so
That's what it looks like
it's
to
a
me.
panoramic image. If I took a panoramic image from any location, it's a panoramic image, meaning it's 360 degrees, and it's just what is captured.
Sure.
If you could spin around, and you could place your head in the same location, could you see the backside of that seat? I would imagine you could.
All right, so I've got a couple of questions for you then. Isn't it possible to just take a picture with a camera from outside the car, or set up a camera inside the car to take the exact same photograph to see that image?
Well, the only way you'd get that same image is if you used a panoramic camera.
Okay.
It's not the exact same.
And you agree a panoramic camera, this panoramic view, is not what the human eye can see?
Well, if it's line of sight, so if you're talking about what is visible in that image, for instance, the steering wheel, the door handles, those things, from that particular point in 3D space, that point is visible from that location. I'm not telling you what anyone saw. I'm just telling you, if you look at that image.
All right, so what you have in your report is that this image shows the approximate view from the driver's, Mr. Harris's approximate eye level.
Yes.
Okay. So did anybody give you any information that Mr. Harris was sitting where the steering wheel was and he was looking at the back of his seat? Did anybody give you that information for you to create that panoramic angle and that panoramic view?
No, sir. So would you suggest that I only do half of an image, or?
I would suggest that what you want to capture is what's accurate.
Gentlemen, questions and answers. Thank you.
Nobody told you that information, that he was, anyone's eye level was where the steering wheel was looking at the driver's seat, did they?
No, sir.
Okay, so you would agree that this image is not accurate of anything that Mr. Harris could have seen.
Looking forward, if you look at the panoramic image, if you position it facing forward toward the seat, you would see that those same objects if you were sitting facing in that direction.
Okay. So if someone was sitting facing the direction where they were looking at the driver's seat, or they were in the place of the steering wheel, this is what they would see.
If they were looking at the driver's seat, no, it's actually closer to the headrest than that.
Okay. And you received no information that Mr. Harris was ever in a position where he was looking at the seating part of the driver's seat.
I did not.
I'll ask you again. This is not accurate of any information that you received that Mr. Harris was in a position to ever have this view.
I'm not sure how to answer that. It's a panoramic image.
I'm gonna ask it as simple as possible. From sitting in the driver's seat, could Mr. Harris have had that very view that you've got depicted there?
He could see a portion of that view.
Yeah.
Would you like to see?
Oh, I can see it. Thank you. I think that's all I've got.
So before you proceed, how long do you anticipate the rest of your presentation to be?
Unfortunately, a little longer than I expected based on that cross-examination. I need to explore some things.
Sure.
30,
Just-
30, 45. Well, actually, I'll try to keep it to 30.
That's not what I'm asking. Let's break for lunch until 1:15.
Oh, yeah.
All right, this court stands in recess.